Hello, I'm Bradley Smith from Smith & Weidinger, and today we're going to talk about what is the difference between driving under the influence and driving while ability impaired, or DUI versus DWAI, and why does it matter? Well, first and foremost, if you've never been accused of an alcohol-related driving event in your life, on a first DUI versus a first DWAI, the consequences in terms of maximum penalties are roughly double. On a DUI, you can do up to 365 days in jail. On a DWAI, that's 180 days in jail on a first offense. Now, not to scare anyone, because it's almost unheard of for a judge to award 365 days or even 180 days of jail, but all the way down the line in terms of fines, court costs, community service, probation, getting a DWAI exposes you to much less harsh consequences. Another area where driving while ability impaired is much better than driving under the influence is when it comes to your motor vehicle rights. Depending on what type of DUI you're accused of, alcohol, narcotics, pharmaceuticals, on a case that involves marijuana or pharmaceuticals, there is no automatic revocation through the Department of Motor Vehicles like there is for alcohol. If you are convicted of driving while ability impaired, you will be able to retain your license so long as you do not go over the point limit. And the important thing to know is that on a driving while ability impaired, that is 8 points against your license, whereas driving under the influence is 12. And if you're an adult over 21, you're allowed to have 12 points in a single year or 18 points in 2 years. So, with all the different parts of the law that come together, both in terms of your exposure not only to jail, community service, length and intensity of probation, but also your driving privileges, it's important to have somebody who can advocate for you to get you from that driving under the influence level down to at least a driving while ability impaired level. And at the end of the day, it's also important to remember that driving while ability impaired just isn't an award for the government not doing a good investigation. Rather, not only do they have to prove beyond a reasonable doubt or have the ability to prove beyond a reasonable doubt that you were driving under the influence, they would also have to have the ability to prove beyond a reasonable doubt that you were driving while ability impaired, or otherwise neither charge can stand up in court. Regardless of your situation, it's imperative to have an expert review all the facts of your case and be able to advise you what the best strategy for your circumstances is. Please reach out to us and call us at Smith & Weidinger at 720-996-7600. Again, that's 720-996-7600, or reach us on the World Wide Web at www.swlaw.co. Again, www.swlaw.co.